It's 10 o'clock, so good morning everyone and welcome to the Hill Dickinson Spring Real Estate Update 2021. We're delighted that once again over 500 of you have signed up to attend our Spring Update, and we'll be serving up our usual mix of property related topics. Now unfortunately we cannot see or hear any of you this morning, but the Q&A box will be open throughout. So please type in your questions as we go along as they occur to you. And once all four speakers have presented, we'll turn to the questions and answer as many as we can, and we will finish no later than 11:30. Today's session is being recorded, and after the event you'll receive a brief feedback survey. We'd be grateful if you would please fill that in for us to help us to plan future events and to improve our offering. Completing that survey will also unlock access to a recording of the seminar and a copy of the slideshow presentation. In terms of our content today, I'll be looking at some recent cases relating to development constraints. Ralph Bullivant from our real estate litigation team will deliver one of his ever popular Landlord and Tenant updates, and David Rintle from our construction team will speak about the use of soft landings in the delivery of new and refurbished buildings. But first, here is Rachel Allen from our real estate team with the news.
Good morning and welcome to our seminar. Thanks for taking the time out of your day to join us. I'm Rachel Allen. I am a senior associate in our real estate team and I normally work between our Liverpool and Manchester offices. So the news at 10:05. First of all, COVID-19. In the autumn webinar, my colleague Tasneem Atia outlined the various protections that business tenants have been afforded during the pandemic period. In particular, landlords can't currently forfeit business tenancies for non-payment of rent. They can't exercise CRA unless much higher levels of rent are owing than usual, and tenants can't be wound up on the basis of statutory demands served since March 2020. Tasneem mentioned that these protections had already been extended more than once, and not long after our autumn webinar they were extended again until the 31st of March 2021. Despite the government saying at that time that this would definitely be the final extension, in the last couple of weeks, the restrictions on forfeiture and CRA have been extended again until the 30th of June 2021. The CRA limits have increased again on the March and they will increase again on the June quarter days. We expect the prohibition on using statutory demands to initiate winding up proceedings will be extended to match. It's estimated that there's now over 4 billion, or according to some other sources, £7.5 billion of rent arrears that landlords have been unable to enforce during the last year. Unless landlords and tenants have reached an agreement, then these arrears aren't simply written off. On the 1st of July, unless extended again, landlords will suddenly be able to take enforcement action or risk waiving the right to forfeit if they fail to do so. Landlords with defaulting tenants and tenants with arrears need to be conscious of this and have a strategy in place. Of course, the government hopes that landlords and tenants will reach an agreement between them, and last summer they published a voluntary code of practice for commercial landlords and tenants that encourages transparency and collaboration. The most recent announcement says that there'll shortly be a call for evidence to assess how this has worked out in practice. Intriguingly, when the protections were extended in December, the government promised in the accompanying press release a review of the outdated commercial landlord and tenant legislation, including Part 2 of the Landlord and Tenant Act 1954. The recent announcement of the latest extension promises that this review will happen later this year, and we wait with interest to see precisely what that review will cover. My colleague Ralph Bullivant will talk later today about some of the problems that the 1954 Act currently causes in practice. Moving on to stamp duty land tax and changes that we've seen there. Following a lot of media speculation and lobbying from the conveyancing industry, the budget on the 3rd of March this year extended the SDLT holiday for residential properties. The holiday is in reality a temporary increase in the nil rate band, so that no SDLT is payable on residential properties up to £500,000 in value or on the first £500,000 of more expensive properties, unless of course the 3% surcharge for second homes applies. So at the moment buyers can save up to £15,000. The holiday is being extended until the 30th of June 2021, and to remove a complete cliff edge when it ends, we're then going to have a half holiday for 3 months afterwards. So from the 1st of July, the nil rate band will be £250,000, and on the 1st of October, the nil rate band will revert to its more usual £125,000. Also on the SDLT front, from the 1st of April 2021, a completely new 2% surcharge will apply where a non-resident individual or company buys residential property. There's some quite complex rules concerning when a buyer is considered to be non-resident. That surcharge is, by the way, on top of the existing 3% surcharge for second homes and company purchases, so that an overseas buyer of a second home will be paying a top rate of 17% on consideration over £1.5 million. Wales, of course, has a different system, land transaction tax, and that's been the case since April 2018. There's been some recent changes on land transaction tax, LTT, also. The holiday in Wales took the form of a temporary increase in the nil rate band for the residential properties up to the value of £250,000. Again, this has been extended until the 30th of June, after which the nil rate band in Wales will revert to the usual £180,000, which is more generous than the position in England, £125,000 normally. Just before Christmas, Wales increased the second home surcharge to 4%. So we can't call it the 3% surcharge there anymore. At the same time as increasing the second home surcharge, the nil rate band for non-residential property was increased by a generous 50%. So that's from £150,000 to £225,000. And that was both on purchase prices and lease rents. And then in February, the relevant rent was increased by 50% from £9,000 per annum to £13,500 per annum. LTT on commercial leases in Wales is calculated separately on the rent and on any premium for the lease. The relevant rent is the maximum amount of rent that a commercial lease can reserve before it loses the benefit of the nil rate band for any premium. The increase means that more commercial leases will be able to claim separate nil rate bands for the premium and the rent. Sticking with tax, we'll move on to some recent changes in VAT. In particular, last autumn, HMRC published Business Brief 12. That requires early termination fees and compensation payments to receive the same VAT treatment as the underlying supply. Although driven by court decisions in very different contexts, particularly mobile phone contracts, this change of policy has obvious parallels in a property context. Think about premiums payable by tenants as a condition of exercising a break clause, or even dilapidations payable at the end of a lease. Most commentators agreed that the new rules caught the break premium, but not dilapidations. But then rumours began to circulate that HMRC were keen to bring dilapidations within scope. Following concerns expressed to HMRC, Business Brief 12 was withdrawn in January of this year, and we were promised revised guidance making the position clear. We expected that guidance initially on the 1st of February, and then on the 1st of March, and now we just don't know when we're going to get it. We have heard mention of September 2021. We understand that the delay is to facilitate discussions with the property industry about how to treat dilapidations. In the meantime, HMRC say we can treat early termination fees and compensation payments as we have done previously, either as further consideration for the underlying VATable supply or as outside scope. For the time being at least, VAT Notice 742 still confirms that dilapidations payments are outside the scope of VAT. Also, a quick reminder from my construction colleagues, the VAT reverse charge came into force on the 1st of March 2021. We've also had some recent updates on the Electronic Communications Code. A couple of years ago, we looked at some of the early cases on the latest iteration of the Telecoms Code, which has applied since December 2017. That talk concentrated on operators seeking new sites for mobile phone masts, including an early case confirming what we'd all suspected, mass rents under the new code, valued in a fictional world where mobile phones don't exist, are going to be much lower than they had been before. Attention's now turned to the renewal of telecoms agreements that were put in place under the previous code. Operators are understandably keen to get onto the new code deals with renewals of existing agreements to take advantage of enhanced rights and lower rents. The code requires agreements that are within the Landlord and Tenant Act 1954 to be renewed under that Act rather than under the code. So an agreement that either falls short of being a lease for whatever reason or which was contracted out of the 1954 Act can be renewed under the code, but leases that were granted within the 1954 Act cannot. Operators fear that a 1954 Act renewal won't necessarily be as favourable to them, particularly on rent, as a code renewal. There have been two significant recent cases that clarify the position. Most recently, in January of this year, Cornerstone Telecommunications Infrastructure Limited and Ashlock Limited and AP Wireless 2 UK Limited, the Court of Appeal confirmed the decision of the upper tribunal there that an operator who was occupying under an agreement that was protected by the Landlord and Tenant Act 1954 must renew under that Act and can't circumvent that Act by applying for a new agreement under the Code. In the autumn of last year, we also had a first case involving a renewal under the 1954 Act, and that was the Vodafone case. Vodafone Limited and Hanover Capital Limited for those who are interested. Although 1954 Act renewals are heard by the County Court, this one was heard by the Upper Tribunal, which hears code cases, sitting as the County Court. But that didn't help the operator. The court set the rent at £5,750 per annum, which was more than 2.5 times the rent that the court said would have been set on a code valuation basis. Of course, following the renewal, the new agreement will be protected by the code rather than the 1954 Act. So the landowner only gets the benefit once of the enhanced rent, and the next renewal will definitely be under the code and subject to valuation under the code. But at least once will soften the blow for landowners. The government's currently consulting on the electronic communications code and 3 particular areas where it isn't working as the government and the telecoms operators would like. Firstly, how do we get agreements in place more quickly? Secondly, rights for operators to upgrade equipment and to share sites with one another. And thirdly, difficulties with renewal of expired agreements. If you'd like to respond, you've really not got long at all. The consultation closes on the 24th of March this year. The final topic that I would like to briefly take you through on a headline basis, is minimum energy efficiency standards, MEES. Climate change is sure to feature high in global post-pandemic politics, and you might recall that since April 2018, the MEES regime has made it unlawful to grant a lease of substandard property unless an exemption applies. A substandard property is currently one with an EPC rating of F or G, but that's going to change. The government recently consulted on a proposal to raise the minimum acceptable EPC rating for residential properties to C, and that's to apply to new leases and renewal leases from 2025 and to all leases from 2028. And within the last week, the government has published a new consultation on MEES for commercial properties, having previously consulted in 2019 and 2020 whether to target a B or a C by 2030. An EPC rating of B is now the confirmed target. The consultation suggests that this will affect 85% of current commercial building stock, requiring 1 million properties to be improved between now and 2030. The consultation proposes requiring an EPC rating of C by 2027 as an interim milestone. This consultation closes on the 9th of June, if anybody is interested in responding. At the same time as the MEES consultation, the government published 2 further consultations last week. That consultation closes on the 9th of June, and it includes a strategy consultation on introducing performance-based policy framework for assessing energy use and carbon emissions in large, carbon emissions in large commercial and industrial buildings above 1,000 square metres in England and Wales. The consultation proposes that owners and single tenants of buildings above that area will be required to obtain a rating for their building on an annual basis and have that rating disclosed publicly online. This will be an operational rating based on actual use rather than a more hypothetical asset rating, so closer to a display energy certificate than to an energy performance certificate. At the same time, a separate consultation was launched on how this proposed new performance framework could be implemented in the office sector as the first of 3 planned phases of implementation. We don't know exactly how things will change or when, but the position is becoming clearer, and anybody who owns or acquires investment properties must accept that the MEES regime is going to become stricter and that action may be required to continue to be able to rent out certain properties. That's all from me for now. I'm going to hand you over to my colleague Bill. Over to you, Bill.
Thank you very much, Rachel. Right, I'd like to take us now on a short but socially distanced journey to Grazington. He says. There we go. Where Grazington developments are seeking to assemble a greenfield development site, part being acquired from local landowner Grazington Estates and part from Grazington Council. And along the way, Grazington developments are going to encounter a number of development constraints that have come before the courts in recent months. Firstly, mines and minerals. It is not uncommon to find exceptions and reservations of mines and minerals mentioned on land registry titles. And Grazington Estates title here is no exception. There's an entry there that the mines and minerals accepted by a conveyance dated May 1980. And if you obtain a copy of that conveyance from the land registry, you'll see it contains a clause saying there are accepted and reserved to the seller all mines and mineral substances lying beneath the surface of the land transferred at a depth below the lowest level of past excavation, but without the right to work or get the said minerals or mineral substances. And that was exactly the position that arose in the recent case of ARC Aggregates and Branston Properties. And that word as I sorted out is actually taken from the conveyance in this case. Now, usually we tend to think of these exceptions and reservations of mines and minerals as being in the nature of the reservation of a right, akin to an easement or a profit a prendre. What ARC argued in this case was that they had actually gone further, and it wasn't just a reservation of a right in respect of the minerals, they had actually retained freehold ownership. They'd created a horizontal title boundary below ground, and in effect had reserved a subterranean ransom strip that came into play once Branston started developing their site and digging down. So the court had to look at this, and they said, although generally transfers have a clause headed exceptions and reservations, they are two different things. Exception is the retention of ownership, so ownership never passes to a buyer. A reservation is where ownership passes, but you reserve some sort of right over the property you have transferred. And the court concluded that the particular wording in this case was an exception rather than a reservation. Ownership of the mineral strata never transferred to the buyer, it was retained by the seller. So like I said, creating a horizontal boundary below ground. And the appeal on this has been dismissed in the last couple of weeks. Now, if that's right, and ownership of the mineral strata has actually been retained, freehold ownership below ground, then if the developer digs down, encroaches into that mineral strata, crosses that horizontal title boundary, then that's trespass, just as much as it's trespass if you build on the land next door that you do not own. So what do Grazington developments do here? Well, it all depends on what's there. They need some sort of geotechnical survey. What is there beneath ground that might be classified as a mineral, and at what depth? They're hoping that the survey will show that there's nothing there within the depth that they need to dig out for foundations, and therefore they can carry on without encroaching and trespassing into the mineral strata. They'll probably also want indemnity insurance against the risk of a ransom claim. But if the survey reveals that there are minerals, there is a mineral strata close to the surface that they cannot avoid encroaching into, then they may have to go and talk to the owner of those minerals and do a deal with them. Now, it's not just the mines and minerals entry on the title that's worrying Grazington developments here. There's also some pretty horrible restrictive covenants. Here we are. Precisely the kind of covenants that you do not want to find on your development site. The first one is a no development covenant, no building structure or other erection of whatsoever nature to be built on the property. The second one is a very narrow user restriction, probably cannot be used for any purpose than open space for the parking of motor vehicles. So obviously any development of this site is going to breach those covenants. So what should Grazington developments do? Do they track down the beneficiary of the covenants and do a deal with them to get them released? Do they apply to court, an application under Section 84 of the Law of Property Act 1925, asking the court to modify or discharge the covenants on the basis that they are no longer needed and impede a reasonable use of the land? Or do you just ignore them, crack on and build in flagrant disregard of the covenants? Well, that's the option that the developer chose in the Alexander Devine case. It got a lot of publicity just before Christmas. And the developer in this case built 13 affordable homes on the land that was subject to those covenants. And the covenants were the covenants I've just shown you on the Grazington title. They reflect the covenants that applied in the Alexander Devine case. So a no build covenant and a very narrow user clause. They built 13 affordable homes on the land. The land with the benefit of those covenants was the site of a children's hospice who wanted to create an oasis of calm and quiet for their patients. With the threat of enforcement action, the developer made their Section 84 application at that point and argued that the covenants should be discharged or modified on the basis that they impeded a reasonable use of the land and that it was contrary to public policy to require them to pull down much needed affordable housing. And this case made it all the way to the Supreme Court. It's actually the first Section 84 application that's ever made it to the Supreme Court. And therefore the Supreme Court took the opportunity to analyse the nature of Section 84 relief. They said that the developer had committed a cynical breach of covenant by just pressing ahead regardless. But they said that that was not relevant to the assessment of whether the Section 84 criteria had been met. So you assess whether there's a breach of covenant, whether there's a reasonable use of the land, whether there's a public policy argument here, and you do not take into account the cynical nature of the breach in doing so. But they said Section 84 relief is a two-stage process, and even if the cynical nature of the breach is not relevant to assessing whether the criteria are met, it is relevant to the second stage, because Section 84 is not an absolute relief. It's not a case of if you satisfy the criteria, you get your relief and the covenants are modified or discharged. It is ultimately a discretionary remedy of the court. What the Supreme Court said was that although the cynical nature of the breach was not relevant to whether Section 84 was satisfied, it was very relevant to the exercise of discretion, and that it was right for the court to deny relief for the developer in cases where there had been this flagrant breach of the covenants. The Supreme Court also pointed out that the developer had essentially recreated the conflict between the public policy and affordable housing and the private rights enjoyed by the children's hospice site. By building, they said, had you made your Section 84 application at the correct time, there would have been no argument, because the court would simply have said, go and build your affordable housing somewhere else. And that by creating the conflict and creating the issue, the developer could not use that to their advantage. Now, the Supreme Court made it clear they stopped short of ruling that every cynical breach will result in an application failing. They did not want to fetter the discretion of the courts going forward. But even so, this is a warning to developers and others that restrictive covenants cannot simply be ignored and must be afforded due respect. Right, Grazington Development's next problem with this site is that it does not directly abut the public highway, and it relies on access rights, a right of way over adjoining land. Now, that's not necessarily fatal, and there are sites all over the country that rely for access on an easement, a right of way over third-party land. And looking at the title, this one has a nice wide easement in the property register, a right of way over the blue land, which is the access land, at all times for all purposes with or without vehicles, for the purpose of access to and egress from the property. That's about as wide wording as you can expect to get. So that's okay then, isn't it? The problem with easements, and particularly for developers, is that the role of the court is to ascertain the presumed intention of the parties at the time the easement was granted. Obviously, the words are key to that. And again, here we have nice wide wording. But the wording is to be read in the circumstances that would have been known to the parties at the time of the grant. So the nature of the right-of-way, the width of the right-of-way at the time it was granted are all as important as the words themselves and can act as natural physical constraints to what could have been used, what the right could have been used for at the time of grant, and therefore constrains what you can do with it now, sometimes as much as any qualification in the words themselves. So yes, it's nice we have this unqualified wording. It doesn't necessarily get us home and dry, and there are frequently disputes and court cases concerning easements and exactly what they allow, what they don't allow. And also you can get into the issues with development, that where if you change the nature and use of the land with the benefit, then that may affect the right of way. Is that going to put an additional unreasonable burden on the right of way? Is that going to affect the rights of the owner of the access land or other people that use it? So easement cases regularly before the court, and here are three I've just picked from the last few months just by way of illustration of some of the issues that arise. The Mills case concerned a nursery operation. At the time the right-of-way was granted, a relatively modest nursery operation, and it relies on an access road and is a right-of-way over that road in connection with the use of the land as agricultural land only. Now, this isn't a case where suddenly the nursery site is changed overnight into a retail warehouse or something. This was a case where gradually the nursery use had developed over time. They'd built a retail area, they'd built a licensed cafe and tea shop, they'd built a large car park. So it was a natural and incremental development of the existing nursery business. But the court ruled that they had diversified into non-agricultural activity on a significant scale and therefore gone beyond the scope of what the easement allowed. So I say it's not a sudden overnight change, but over time, the development of the business and the site took them beyond what the easement allowed, and the easement did not support the current use. The Mcgill case is an interesting one. It was a house that was sold off with a right-of-way over the lane that accessed the house, right-of-way granted over the lane with or without private motor vehicles. Current owner of the lane argues that a restriction with or without private motor vehicles only allows the lane to be used for private motor vehicles, private cars, no commercial trade vehicles at all. And despite relatively clear wording there in the easement, the court said, well, that can't be what they meant. We presume that what they really meant was that the use of the access lane would be limited to purposes in connection with the use of the land as a private dwelling and vehicles that were necessary or consistent with the continued user of the land as a private dwelling. So the postman can deliver post without being in breach, the plumber can come, the man can come and empty the septic tank. So commercial vehicles consistent with the current use and ongoing use of the land as a private dwelling, but not, for example, construction vehicles should the owner of the house want to redevelop it. So potential problems there if they want to redevelop that site. Most recently, the Bucknell case. This was a case, again, with a nice wide easement at all times for all purposes with or without animals or vehicles. But despite that wide wording, the owner of the access road has been granted an interim injunction preventing the use of the access road by construction vehicles pending a full trial as to what exactly is and isn't permitted over the access road. Again, this is another case where the nature, particularly the width of the access way at the time of grant is an issue and may act as a constraint now, despite what appears to be fairly wide wording. So it is important, particularly when you are going to develop a site and change the nature and use of the land, to make sure you are happy that your easements are sufficient, both during the construction phase, where you're going to have perhaps a lot of construction vehicles using the access routes, but also for the ongoing use of the site once it has been developed. So, having successfully resolved or satisfied themselves on all the title issues, Grazington Developments go ahead, get their planning permission, and then complete the purchase of the site. Now, I mentioned earlier that part of the development site was being acquired by the council, and following the purchase, Grazington Developments find themselves on the receiving end of judicial review proceedings brought by a concerned local resident. Those proceedings are quoting the Open Spaces Act of 1906. Now, I don't know about you guys, not an act I'm particularly acquainted with. So what is this all about? Well, under the 1906 Act, if a local authority acquires land as open space, it holds it, as what the Act says, in trust to allow and with a view to the enjoyment thereof by the public as an open space within the meaning of the Act. So essentially the land is held in trust for public enjoyment. Section 20 of the 1906 Act defines open space as any land, whether enclosed or not, on which there are no buildings or of which no more than 1/20th part is covered with buildings, and the whole or remainder of the land is laid out as a garden or used for the purposes of recreation, or, and this is significant, or lies waste and unoccupied. So open space might be laid out as a garden or recreation area, might be wasteland, held under a statutory trust. Now, if a local authority wishes to dispose of public open space, there is a procedure in the Local Government Act 1972 requiring advertising in a newspaper circulating in the area, etc., etc. And if that procedure is complied with, the statutory trust comes to an end. There's a separate provision in the Local Government Act that says if the procedure is not properly complied with, a buyer still obtains good title. In our case, the local resident is alleging that because of the failure by Grazington Council to comply with the proper procedures, that although Grazington Developments undeniably get good title and now own the land, but the defects in the procedure mean the statutory trust has not been terminated, and therefore Grazington Developments own the land, they have good title, but subject to the continuing statutory trust. And that is precisely what happened in this recent case. This was land that Shrewsbury Town Council had acquired back in the 1920s. It had been used as allotments during the Second World War, but in recent times had just become wasteland. The council sold it to a developer who got planning permission for development, completely unaware of the nature of the land and the statutory trust and the requirements. And the complainant, they sought judicial review of the planning permission granted to the developer on the basis that planning should not have been granted because the statutory trust continued despite the developer having a good title. This case made it to the Court of Appeal. Now, fortunately for the developer, the Court of Appeal did not dwell on the precise wording of the Local Government Act provisions, which I think would have been problematic for the developer. They instead took a pragmatic approach and said that where a developer acquires the land from the council without knowledge of the trust, without knowledge of the failure to comply with the requirements, then getting good title means they get good title free from the statutory trust. Quote from the case, "In other words, he will take the land without the burden of the Section 10 trust unless he has actual knowledge that the requirements have not been met." So the developer in that case was okay because they were unaware. So ignorance is bliss seems to be the suggestion in this case. What you don't know doesn't hurt you. But as a developer buyer, you just need to be careful. Has anything been said in negotiations? Has anything come out in replies to a local search or replies to pre-contract inquiries that could arguably put you on notice as to the status of this land? It will always be a tactical decision, but maybe if you are buying open land from a local authority, it might sometimes be better to raise the issue up front and make sure that it is dealt with properly rather than face a challenge after the event. So, having finally negotiated all these obstacles, Grazington Developments are finally able to commence their development. And while they get on with that, I'm going to hand over to Ralph for his Landlord and Tenant update.
Thanks, Bill. Hopefully you can all hear me. As most of you will know, I'm Ralph Bullivant and I'm a consultant in Hill Dickinson's property litigation team based in Liverpool. And I'm going to be talking to you for the next 15-20 minutes or so about the Landlord and Tenant Act 1954. And as Rachel indicated, on a couple of cases that sort of highlight some of the issues that can arise out of the Act. Now, I've been doing this work for 25 odd years. When I first started, we didn't have trainee solicitors, we had article clerks. And as an article clerk, my first involvement with the Landlord and Tenant Act 1954 was being sent to Oxford County Court, clutching a set of papers with a view to seeking an order to get a lease excluded from the protection of the Act. Because, of course, what the Act does is it provides security of tenure, so that if you're a business tenant occupying property under a lease, when that lease comes to an end, the landlord can't automatically get rid of you unless he can satisfy certain grounds. And when the Act was first introduced in 1954, all leases were protected by it, so all commercial leases were protected by it, and there was no mechanism whereby leases could be excluded from the protection of the Act. That changed in 1969, as it was thought that if a landlord and tenant had agreed that they wanted a lease to be excluded from the Act, then there should be a mechanism in place to allow that to happen. And for a long time, the mechanism was, as I indicated before, the parties having to toddle off to court, issuing an application, what was called an originating summons, paying over a cheque for £100 or so. An originating summons, a copy there on the screen, not dissimilar to what would have been used then. One then had to find a friendly district judge who was prepared to make the order, and invariably they were, and the lease would be excluded from the Act, and there'd be endorsement on the lease, again not dissimilar to what you see on the slide here, dating the court order and containing the court claim number. But over time, it was felt that it was perhaps unnecessary to involve the court in this process, and all that changed in 2003, 2004, when we had the Regulatory Reform Business Tenancies Order 2003. It came into force on the 1st of June 2004, and lawyers like me went up and down the country talking to people like you about the changes that it brought in. And one of the big changes it brought in was to take out of the court process the mechanism whereby leases were excluded from the Act. That's worth noting that at the time the Act came into force, every year there were approximately 54,000 court applications to exclude tenancies from the Act. So if the court fee was £100 ago, that was quite a bit of money that was being earned by the court system, which they chose to forego. But anyway, the new system came into force in 1st June 2004 and simplified matters and meant it was no longer necessary to involve the courts. And basically, as most of you will know, it works by the landlord serving on the tenant a warning notice, telling the tenant that the lease that it's about to complete will be excluded from the protection of the Act. And the tenant then signs a declaration, and that's either a simple declaration, or if the lease is going to be completed less than 14 days before the declaration is signed, a statutory declaration, just to confirm really that the tenant understands the lease is going to be excluded, which of course means that when the lease comes to an end, then the tenant can be required to vacate and won't have any opportunity to renew the lease. And since 2004, I think it's fair to say that the system has worked reasonably well. It's mostly dealt with by my transactional colleagues, and they deal with all the notices that need to be served, the declarations that need to be signed, etc. And there have, perhaps surprisingly, been very few cases that have come to court whereby people have sought to raise queries in relation to the procedure. But we now have a case, TFS Stores, which came to court in November 2019 and has continued to rumble through the court system over the course of last year, and provides perhaps quite a helpful insight as to how the court will deal with these matters and some of the arguments or potential pitfalls that arise in terms of excluding security of tenure. So I say the case involved TFS Stores Limited, otherwise known as the Fragrance Store, and they operate small shops in shopping centres up and down the country, selling perfumes of one sort or other. Case actually involved a total of 6 leases, 6 different properties and 6 different landlords, and kicked off in 2017. The background being that back in 2007, TFS had entered into 2 leases in relation to properties, I think at Mansfield and Bainbridge, I think they were. Those leases were for terms of 10 years and were to be excluded from the Landlord and Tenant Act 1954. Those leases came to an end in 2017. And rather to the surprise of TFS, rather than the landlord wanting to give them new leases, the landlord said, no, these leases were excluded. They've come to an end. We want you to move out. TFS was slightly alarmed by that. They were surprised the landlord didn't want to renew, and they were upset when it came to their attention that in fact what the landlord wanted to do was grant new leases in relation to these 2 properties to a competitor of TFS. So the competitor would effectively go in, take TFS's goodwill, and TFS would be excluded. So TFS decided they weren't going to have this, and they made application to court for declaration in relation to those 2 leases that in fact the process whereby they had been excluded hadn't been properly followed. This came to the attention of 4 other landlords who had similar leases in relation to, well, had similar leases which had been excluded, which were due to expire, and those 4 other landlords in turn made separate applications to court for declarations to say that the leases have been properly excluded from the protection of the Act. So there were a total of 6 leases before the court, 6 different landlords and 6 properties. Came to the High Court in November 2019, and there were effectively 3 arguments that TFS Stores sought to run. The first was that they said the solicitors who would accept service of the warning notices lacked authority. So go back to what I said before, the new process in relation to excluding tenancies meant that the landlord needed to serve on the tenant notice that the lease was to be excluded. TFS sought to argue that in this instance the notices had been served on solicitors and those solicitors lacked authority. The second argument that was run was that the person who had signed declarations to confirm and acknowledge that the leases were going to be excluded lacked the necessary authority. And the third argument was that there was a discrepancy in relation to dates, being the dates on the leases actually commenced and the wording within the form that needs to be completed about the commencement date. So going through each of those issues in turn. In terms of solicitors lacking authority, of course, most landlord and tenant transactions are dealt with solicitors acting on behalf of the parties. So solicitors acting for the landlord and solicitors acting for the tenant. And in that respect, in terms of going through the process, it does make life substantially easier if the tenant solicitors can accept service of the notice rather than having to serve the tenant directly. So it's fairly standard for solicitors to accept service of the warning notice. But here, say TFS sought to argue that the solicitors lacked the authority to accept service of those notices, and that in fact the notices should have been served on TFS stores. The court wasn't having any of that. There was some looking back at the solicitors' files and to who had done what in relation to the transactions. Some of the solicitors gave evidence in terms of the trial, something that puts the fear of God into most solicitors having to give evidence. But the court was satisfied that the solicitors had been instructed in relation to the transaction. They were the solicitors acting. They were the solicitors named in the heads of terms that had been agreed, and it was clear they had indicated they had authority to accept service of the notices. So on that basis, the court was satisfied that the solicitors had the necessary authority. Second argument raised by TFS was that the person signing the declarations lacked authority to do so. So although the notices are normally served on the solicitors, they will get someone from the tenant company to sign the declarations. Here, the declarations were signed by a gentleman who was effectively the property manager for TFS and was responsible for all their property transactions. And in fact, I think had negotiated these particular transactions back in 2017 on behalf of TFS. He'd been the person named in the heads of terms, and clearly the court said that he had authority to sign the declarations. It seemed part of the issue here was the chief executive of TFS Stores, Mr. Videra. And Mr. Videra had obviously taken the view that these particular landlords would be wanting to renew these leases, although the leases have been excluded, and it came as a bit of a surprise to him when the landlords didn't want to do that. So it was him running these arguments in terms of the process not having been properly followed and this gentleman not having the necessary declaration. But Mr. Videra had signed off on the leases. He'd signed them on behalf of TFS Stores. It was clear that the leases were to be excluded. So although Mr. Videra may not have fully understood the process, the court was satisfied that the person who'd signed the declarations had the appropriate authority. Then the third issue they sought to raise was a discrepancy with regard to dates. Now on this slide, I've got an example of the statutory declaration that needs to be signed by the tenant. And you have the name of the person signing the declaration, you have a description of the premises, and there it says for a term commencing on, and then there's a blank to put in the date on which the lease is due to commence. Of course, part of the difficulty with this is that although you're meant to complete this form, you complete this form a few days, or if not weeks, before the lease actually starts. So at that stage, there may not be any great certainty as to the term commencement date. So over time, solicitors have involved various sort of formula which they put in there in order to be able to address that, either to say the date is to be ascertained, or the date of commencement is the date the lease is completed, or something similar. And on occasions, I think that box is actually left blank. But TFS Stores sought to argue that there need to be strict adherence to the wording of the form, and the wording required that the term commencement date be there. And if there was some ambiguity or discrepancy with regard to that, that meant the process hadn't been properly followed. The court wasn't having any of that, and pleased to say this is an example of the court showing some good common sense. The matter was dealt with by His Honour Judge Davis White QC, and he said on these arguments as follows, as set out on the slide. This seems to me a recipe for confusion, uncertainty and frustration of a sensible commercial arrangement entered into between prospective landlords and tenants. It also seems to me a situation where, if this is indeed the position, commercial parties might well with justification say that the law is an ass, and I do not consider that this does represent the law. I think probably what the judge had in mind is that if he had decided for TFS Stores here, that would have meant solicitors up and down the country going back through files to 2004 to see whether or not these issues highlighted by the case might have arisen in relation to leases that have been excluded. And I think it would have been found that a large number of leases entered into since 2004, which people had assumed had been excluded, were in fact did in fact have the benefit of the protection of the Act. So, as I say, some rare common sense from the court, and a good result on the face of it for the landlord. However, although His Honour Judge Davis White declared here that to decide in favour of TFS Stores would be to show the law as being an ass, we now have a picture of an ass, which I suspect is how the landlord now regards the law, given the way that the case has now progressed. Two issues. I mean, Bill mentioned a fairly historic act, being the Public Open Spaces Act 1906. I can actually trump that with an act which is still on the statute book, and is even more historic, and that's the Landlord and Tenant Act 1730. And what that act says is that if a tenant willfully holds over after his tenancy has come to an end, then the landlord can require that tenant to pay either double value or what's sometimes known as double rent in relation to that continuing occupation. Here the landlords had said that these leases clearly had been excluded. TFS Stores clearly knew that was the position. It sought to run these rather sort of spurious arguments to try and be able to stay in the properties for longer. This was clearly willful, and so they should pay double value. I think perhaps surprisingly, the court said no to that. The court said that TFS Stores had the benefit of very high-powered legal advice. In fact, they're represented by Guy Featherstone Hall QC, one of the leading, if not the leading, property barristers in the country. And so there are arguments to run in relation to whether or not these leases were excluded. And on that basis, the court said they were not willfully holding over and so did not have to pay double value. I have to say I find that slightly difficult to reconcile with the argument, with the decision of the court that to follow the arguments being run by DFS stores would be to show the law as being a bit of an ass. So I find that slightly difficult to reconcile, and obviously a disappointing decision so far as the landlords are concerned. But it gets worse for the landlords. TFS stores appealed these decisions, and the appeals were due to be heard by the Court of Appeal in June last year, June 2020. But of course, by then we had the pandemic, and Rachel has already mentioned some of the legislation around CRA and forfeiture, which restricts what landlords can do in relation to commercial premises. There is another restriction in that any possession proceedings are also automatically stayed, or have been automatically stayed, and I think that automatic stay has been extended to June this year in line with the restrictions on CRA and forfeiture. So as I said, these matters were due to come to the Court of Appeal in June last year, but TFS stores turned around and said, well, hang on a minute, so far as we're concerned, these are possession proceedings, because if the landlord is successful in defeating the appeal, he'll be entitled to possession. So these are in effect possession proceedings, and so the appeal should be stayed until such time as the coronavirus legislation lifts the stay. I think perhaps surprisingly, again, the Court of Appeal agreed with that and said, yes, these are possession proceedings and the appeal should be stayed. And so the legislation, so the litigation has been kicked off into the long grass. TFS stores are able to still be in the properties. They may not be trading at the moment, but they're still effectively in occupation. There's yet to be a final resolution of the case. So in relation to some of these leases which had expired in 2017, for the landlords, there's still no certainty as to when they're going to be able to get back possession. So whilst there was some common sense so far as the court was concerned, the landlords may have some justification for thinking that perhaps there are elements of the law that are still a bit of an ass. But moving on to an ass, we move on to another equine creature, and a picture of a horse. And I'm told that we need on these things to try to build up some interaction with our audience. So a quick question for you. If you're able to identify the name of the horse and the relationship between the rider and the case I'm about to talk about, please put the answer in the questions and answer box, and I'll try and find it when we get to the end of my talk, and I'll be able to announce who the winner is. I'm afraid there are no past prizes, but you will have the satisfaction of being able to say that you're able to Google the answer in the 5 minutes or so that I'm going to spend talking about this next case. So the case is Kent and Guest, and it was decided earlier this year. And again, it's another case arising out of the 1954 Act. It involves some racing stables near Wetherby in Yorkshire. Mr. and Mrs. Kent bought these racing stables with the intention of running them as a racing stable. But they weren't quite ready to start doing that. They wanted to build a house on the land that they bought for them to live in. And whilst that house was being built, they wanted someone to run the riding stables for them. And they came to an agreement with Mr. Guest. Mr. Guest had previously run the riding stables for the previous owners, and he said that he would continue to do so. And the parties reached an agreement whereby a lease of the riding stables was granted to Mr. Guest for a period of 1 year. That lease was to be excluded from the protection of the Landlord and Tenant Act, so that when it came to an end, Mr. and Mrs. Kent could be sure of getting back vacant possession. However, and it's not quite clear why, somewhere along the way, Mr. and Mrs. Guest got the procedure wrong. The suggestion is that they'd failed to give the appropriate notice to Mr. Guest, as a result of which, at the end of the year, when Mr. and Mrs. Kent sent to Mr. Guest, your lease is coming to an end, can you please vacate? Mr. Guest said no. He said he'd failed to follow the correct procedure, and I'm therefore a protected tenant, and you can't get rid of me. And for added benefit, Mr. Guest also said that this house that you've just had built on the land, because it's part of the land which is let to me by the terms of the lease, so far as I'm concerned, I'm the one who's entitled to live in the house, and you can't move in. So Mr. and Mrs. Kent went away, thought about it, and agreed that the lease was not excluded, and so served on Mr. Guest a hostile Section 25 notice, terminating Mr. Guest's tenancy and saying that they weren't prepared to give him a new tenancy on the basis of grounds A and C. These are the fault grounds. So in relation to A, they said that Mr. Guest had allowed the property to fall into disrepair. And in relation to ground C, they said there were other breaches of obligations under the terms of the lease. And in relation to ground C, the full wording of that is that the tenant ought not to be granted a new tenancy in view of other substantial breaches by him of his obligations under the current tenancy. So there need to be substantial breaches. And Mr. and Mrs. Guest said, Mr. and Mrs. Kent said that there were substantial breaches. The property had been allowed to fall into a state of repair. Maintenance was required. Mr. Guest was in breach of his statutory obligations because the local authority was complaining about him burning waste on the ground. He'd carried out unauthorised alterations. There's an unauthorised sharing of occupation, and it also failed to pay the insurance required in relation to the property. It was first heard by a recorder in the court in Leeds, and the recorder agreed with Mr. and Mrs. Kent that there were breaches of the terms of the lease, and that as such Mr. Guest wasn't entitled to a new tenancy. However, Mr. Guest then appealed that decision to the High Court in Leeds, and that was dealt with earlier this year. And basically, his appeal boiled down to the fact that ground C requires that there be substantial breaches, but in his decision, the recorder who came to the first instance decision had failed to use the word substantial. He'd outlined the breaches that he'd found, and he clearly decided that there were breaches in relation to the tenancy, but he'd not used the word substantial. The High Court wasn't having any of that. He said it was clear, if you look at the breaches that the recorder had found, that these breaches did amount to substantial breaches, and as such, the High Court was satisfied that Mr. Guest was not entitled to a new tenancy. Sorry, Mr. Guest wasn't entitled to a new lease, and that Mr. and Mrs. Kent were entitled to possession. So quite an interesting case to look at, where if you look advising in relation to a hostile Section 25 notice, where the court has been asked to look at some of those fault grounds where it needs to exercise its discretion. Right, that's the end of my talk. So I'm going to quickly look to see if we have an answer to the question. Very exciting. We do. We have an anonymous. Two people have come up with answers. Anonymous says it is Red Marauder and the jockey was Richard Guest. Quite right. And Debbie Reynolds, well done, Debbie Reynolds, also correctly identifies the horse as being a Red Marauder. So there were prizes. There'll be 2 prizes on its way to you. But in the meantime, so you have the satisfaction of knowing that you got the answer right. So thanks very much for coming back on that. And I'm now going to hand you over to David, who's going to talk to you about soft landings. Thanks very much.
Thank you very much, Ralph, for that introduction. And as Ralph says, I'm going to talk to you about soft landings. Soft landings is a process that looks to improve the whole life value of built assets. And as head of the construction team in the London office and as a construction lawyer, with our focus being on advising on how new build and refurbishment projects should be procured and documented, we're always looking at how we can support clients focus not just on the build cost, but on eventual outturn costs. And clients necessarily procuring a new build or refurbishment project are usually focused on getting their construction projects delivered on time and on budget and to the necessary quality. Those clients that own the building then hand over at the end of the construction phase typically to the facilities manager, who is often rarely involved before this point, giving him or her a bundle of information, drawings, certificates, etc. from the contractor and design team, the as-built drawings, so that they can then operate and maintain the building. Sometimes the client passes on the building to an investor or tenant and lets them deal with this aspect. However, if there are issues or defects in the works, or the building doesn't otherwise operate as intended and supposedly commissioned, then this often leads to claims after practical completion and the expiry of the defects liability period against either the contractor or the professional design team under the terms of the building contract, design appointments, or any collateral warranties that might have been granted. So soft landings is therefore a different approach and offers a different approach in both public and private sectors to dealing with the handover of a building from the contractor to the developer or user. The two key features are facilities management being incorporated into the initial brief and followed through the entire period of construction and design, with the design team secondly staying involved post-completion for a post-occupancy evaluation period that is intended to fine-tune and debug commission systems and ensure occupiers understand their buildings better, such that soft landings, as I say, is intended to improve the whole life value of the built asset. Soft landings as a concept dates back to 2009 and was developed by BISREA, the Building Services Research and Information Association, focusing on the built environment. It's a cradle to operation project process that allows designers and constructors to focus more on operational performance outcomes. This helps or should help to ensure that buildings are delivered achieving their energy and environmental performance ambitions with a focus on the needs of occupants. It's therefore intended to facilitate and ensure that any bumps between completion and operation are kept to a minimum, hence the term a soft landing. The BISREA Soft Landings Framework was first published in 2009 and most recently updated in 2018. It's a series of steps and guidance, a methodology, if you will, that can be tailored to the project specifically in question. They can apply equally to new and refurbished buildings and alterations, and importantly, given that we've got a range of representatives attending this webinar from across the private and public sector to both public and private sector contracts. Soft landings introduces supplemental activities to the construction project process so as to achieve a more performance-driven outcome, including success criteria, performance targets, and methods of evaluation. In June last year, 2020, the Better Buildings Partnership and BISREA published a joint report called Soft Landings, the Benefits to Commercial Property Owners. The focus of this report is on the property sector's growing ambition and desire to support the transition to net zero carbon. A good example of the, quote, performance gap, unquote, is that actual energy performance data has no correlation with EPC ratings of office buildings. Soft landings was equally adapted in 2011 by the government for the implementation of the government soft landings. So government soft landings is different to BISREA's soft landings framework that I've just introduced, as it is not an integrated and collaborative client/delivery team process like BISREA's, but instead comprises a set of facilities management driven requirements for a well-performing building. It contains a set of activities and tasks on project delivery. These are mostly defined and managed by a government soft landings client sponsor and a similar project government soft landings champion, either typically appointed by a government department internally or sourced externally. I should say that government soft landings is mandatory for all central government projects from 2016, and alongside building information modelling, BIM on the slide you'll see there, BIM involves storing and representing information relevant to the design and construction and future operation of a building in an electronic form readily accessed by the entire project team. One good example that I can give to you of government soft landings in action is that all school construction projects now use the Department for Education's soft landing strategy. As some of you may also be aware, the Building a Safer Future independent review of building regulations and fire safety, published after the Grenfell Tower fire in 2017, focuses as a report on high-rise residential buildings, and it of course highlights the concerns that processes that drive compliance with building safety compliance were weak and complex, with lack of proper record keeping. The report called for what is known and become known as the golden thread of good quality information to be generated, so that building owners can get the information they need with a clear link between design, construction, operation and maintenance. Many senior industry figures within the construction industry think that soft landings together with BIM will help generate this required golden thread. Whilst the BISREA and government soft landings frameworks are aligned, and there are many similarities, there are some differences between the two. In broad terms, the BISREA soft landings framework encourages increased collaboration and awareness of outcomes through stakeholder workshops and design reviews, with programme and formats defined by the soft landings champion. Government soft landings, on the other hand, is more prescriptive in relation to the BIM processes being checked against project targets. And in the remainder of this presentation, I will be focusing on the BISREA soft landings, given its widespread use in the private sector. So I've just gone ahead of one slide. So how does soft landings framework 2018 work? Well, it requires clients to appoint designers and constructors to stay involved with the building post-practical completion for an initial 3-year post-occupancy evaluation period that I mentioned previously. The aim of this period is to help facilitate facilities managers and occupiers to understand how to control and use their building with a view to optimizing the operation and maintenance. At the end of the 3-year period, the building can then be judged against the performance targets set and any discrepancies accounted for. So the question is, can these principles be applied to environmental targets such as energy efficiency ratings and carbon emissions? Well, very much so. The soft landings framework is a process that describes the activities, roles and responsibilities over 6 key project stages. And these project stages are very much designed to coordinate with and be aligned to the typical RIBA, the Royal Institute of British Architects stages 1 to 6 for design, from inception and briefing through to the maximum 3-year aftercare period. BISREA say that soft landings works best when clients are engaged. The client must lead the process together with funds and other institutional investors and ensure that soft landings is properly embedded into the project and all the contract documentation. BISREA recommends a soft landings champion. The project champions are often called the soft landings leads, with the client-side champion recommended to be the facilities manager, so as to ensure that the facilities manager gets involved very early on in the project and gets opportunity to comment on the design and make sure it's consistent with the intended subsequent operation of the building. They will have the opportunity thereby to influence the design and original specification. On the slide in front of you now, I've put forward a breakdown of the soft landings framework 2018 and the typical 6-phase approach that's adopted from inception to completion and beyond. It's intended to complement the other activities. So the approach is largely similar to that adopted under the original 2009 framework, but it also includes post-occupancy evaluations, typically at 12 months post-handover, and repeated at 12-month intervals thereafter until a final project review at the end of the 3 years. So to take each of the phases or stages, the first stage, known as Inception and Briefing, that you'll see on the slide, at this stage the parties meet to clarify their respective roles and responsibilities. The parties define the client requirements, set goals for performance, and define the success criteria by which the project will be measured. There will also be the instruction at that stage of the soft landings champion and leads, recommended, as I say, to be the facilities manager. The second stage, design development, including specification and construction. Typically, many projects here in the UK are procured on a design and build basis, with the contractor undertaking responsibility for much, if not all, design. The relevant teams engage collaboratively in workshops, reviewing the likely performance against the original expectations and ensuring the project can be achieved. Construction, the third stage. Here, the facilities manager and end user need to be more closely involved in the project than would otherwise be the case, implementing and taking part in decisions that affect subsequent operation and management. The fourth stage is at pre-handover, where there's a greater involvement of designers, builders, operators, commissioning and control specialists, so as to strengthen the operational readiness of the building. These specialists ensure that the facilities teams understand the systems and controls within the building. Following practical completion, there's then an initial aftercare period. The user of the building is settling in. A representative or part of the design team are based on site to pass on knowledge, respond to queries and react to any teething problems that we typically see with, say, for example, commissioning of mechanical and electrical systems. And then in the aftercare period, years 1 to 3, involves the periodic monitoring and review of building performance through energy monitoring, fine-tuning, and indeed, and importantly, occupant surveys to ensure that they're satisfied with the end product. Necessarily, with all of this, and bearing in mind I said at the outset, it's important to ensure that the roles and responsibilities are properly documented. This brings into sharp focus legal and contractual issues that arise when introducing soft landings into a procurement process. The incorporation of soft landings and the use of the framework clearly impacts on the services being provided by everyone involved in the project, including an extended handover period of 3 years or so at completion to carry out any annual post-occupancy evaluation. What then are the legal and contractual issues? Well, firstly, soft landings can apply to any type of procurement, both traditional, where the employer and their design team carry out the design work and the contractors engaged to build to that design, or, as I mentioned, design and build. Some 40% of projects in the UK are undertaken on a design and build basis, whereby the contractor takes full design responsibility. Other types of contracts that can be used include alliancing, a type of partnering contract, and where the parties work together and collaborate to deliver a project, which theoretically would be ideally suited towards incorporation of soft landings, it being aligned with the underlying philosophy. Alliancing enables the owner of an asset to take an active involvement in a project, aligns the interests of the members of the project team with those of the project as a whole by way of a pain gain share mechanism, and encourages parties to operate in a frank and open manner, requiring them to agree not to pursue claims in the event of disputes except in very limited circumstances. Although in my experience, alliance contracts are rarely used, but take-up may well increase. There is a JCT being the standard industry form of constructing excellence contract, which is an alliance contract, and the equivalent contracts for civil and infrastructure projects, the new engineering contracts, also have a recently published alliance contract. The second point I make on the slide is that soft landings framework is for guidance only, and it sets out process recommendations. The intention is that the parties enter into workshops to agree how the framework should be incorporated into the project and identify specific duties and client requirements that need to be included in the tender documents. And thirdly, the soft landings framework applies to all of the project participants, or at least it should. As well as the various phases during construction, soft landings requires clients to appoint designers and constructors to stay involved with their new building beyond practical completion for the 3-year period I've outlined. It's important that all project participants, design team, contractor, specialist subcontractors, including the facilities manager, sign up to the framework. Early appointment of these parties and clear identification of their respective soft landings roles and responsibilities is essential, because obviously that then helps to ensure early identification of the project brief and management of expectations. Clearly, this is likely to attract additional fees. The client is also going to consider appointing a soft landings champion, as I've said, typically the facilities manager, whose role is to oversee, monitor and coordinate all project compliance with the soft landings process. If the soft landings initiative is to be used, it's important that all parties involved in the project sign up to the framework from the outset. Therefore, consideration needs to be given as to how, within the framework, the respective roles and responsibilities of each party can be incorporated into the relevant contractual provisions. Requirement to sign up to and adopt the recommendations of the framework can be mandated through incorporation into the design team appointments and build contract for use on the project. And typically that would require amendment to the applicable standard form contracts and appointments that we typically see. The fourth issue I wanted to touch on is the question of the extended post-occupancy evaluation period of 3 years. Typically, of course, under a building contract, the contractor remains on the hook to remedy any defects after practical completion for a typical 6 or 12-month defects rectification period. And subsequently, at the expiry of that, if defects become known after the expiry of that 6 or 12-month defects, so-called latent defects, then the contractor is obliged to come back and remedy those too. But often compliance is observed more in spirit than actuality. Within building contracts and appointments that we typically see within the construction team here at Hill Dickinson, consideration is often advised to be given to clients to the definition of practical completion, because the standard forms do not define what constitutes practical completion and what must be achieved and what documents must be delivered up before practical completion is certified by the employer's agent or contract administrator. And this can lead to dispute as to whether or not practical completion has been achieved or properly certified. Definitions within the standard form contracts do get around this problem by making clear what specific precondition precedents must be achieved to allow certification of PC. And this is obviously important where we get third-party project funding, with the project monitoring surveyor engaged by the fund also requiring to have input into whether or not PC should properly be certified to enable additional drawdown of funds. If soft landings is incorporated, then this could involve certification of practical completion being conditional on review and approval from the facilities and operations manager, and perhaps involving testing and commissioning of the M&E systems to an extent more widespread than we sometimes see. Equally, with the introduction of a 3-year post-occupancy evaluation period, careful consideration should be given to the definitions of defects against mere performance issues or teething problems. Soft landings aftercare runs alongside defects warranty periods and beyond that. So there needs to be care that there's no mix-up with snagging items, being items of defective works minor in nature that don't affect the beneficial use and occupation of the building. Soft landings isn't about fixing things that do not meet the output specification. Rather, it's about identifying things that are not defects, for example, shortfalls in performance, in controllability, and dealing with the unintended consequences of system operation, for example, automatic lighting systems, whether or not motorized windows work, and so on. An important issue in construction contracts is, of course, project insurance. In light of the increased involvement of design and construction teams post-practical completion, insurers may take a view that the projects pose an increased risk when compared to a traditional build. Insurance providers can introduce restrictions to account for this increased risk and reflect the responsibilities of the design and construction teams post-completion. It's obviously important that the parties obtain and maintain appropriate insurance cover, expressly covering project requirements, specifically the increased obligations post-completion that are carried out under the soft landings framework. Similarly, beneficiaries under collateral warranties or other third-party rights should ensure that those warranties or third-party rights obtain and maintain appropriate insurance cover from the provider of the warranty or rights. While almost all projects are undertaken with the traditional insurance provisions in place, covering, for example, contractors all risk, third party and consultant, and where appropriate, contractor, professional indemnity, design liability insurance, some public sector soft landings projects have adopted what has usefully become known as integrated project insurance models, initially published in 2014 and reconfirmed in the 2016 government construction strategy. This provides integrated insurance for all project risks to include time and cost overrun. The use of integrated project insurance helping to avoid the blame culture historically prevalent in the industry, encouraging greater collaboration and alliancing between all project participants, and so fulfilling the intent behind soft landings process and framework. And of course, another benefit of it is that it reduces the costs of procuring project without multiple parties having to take out and maintain duplicated insurances across the piece, for example, professional indemnity insurance. And finally, building information modelling, or BIM, which I've introduced previously as being going hand in hand with government soft landings. It's recognised within the public sector that there's a natural synergy between BIM and soft landings, as BIM provides the data required through the soft landings process, for example, the post-occupancy evaluation. Some of you may be seeing an increased use of BIM on private and indeed public sector projects where it's mandated, and BIM and the related provisions should expressly be incorporated into contracts through amendments to the standard forms. So in summary, the key takeaway that I want to leave with you is that soft landings is designed to ensure that the client gets a better building and to avoid bumpy handover between construction and operation. Use of soft landings initiatives are clearly gaining in popularity and use, not just across public sector, with its support from the UK government and on public projects such as schools and hospitals, but also the private sector too, where it's gaining increased traction. If you go to the BizRIA website, you will see some case studies there, and also in the 2020 soft landings report for commercial property owners. I mentioned at the outset the Building Safer Future report by Dame Judith Hackett following the Grenfell fire and inquiry, and her comments that there needs to be this golden thread for all complex and high-risk building projects so that the original design intent is preserved and recorded. Supporters of soft landings think that it, together with BIM, does produce that golden thread of information, because at its heart, it's intended to be a collaborative process. This is at odds with the otherwise antagonistic stance sometimes taken in construction projects, and perhaps for more widespread take-up, there needs to be a fundamental culture shift within the sector, with clients not just focusing on actual build cost, but looking at the eventual outturn cost and how those costs can be reduced. Finally, a question for you, whether or not soft landings is for you and your clients and your projects. I can't answer that, but hopefully this talk has given you some pause for thought so that you may want to go away and find out more. I'll be happy to provide some links to the resources I've mentioned in this talk if you'd like to get in contact with me after the event. And I'm just putting up our contact details on the slide there if you'd like to follow up with Ralph, Bill, Rachel or myself. And now handing over to you for any questions and answers, if Bill can take the chair, please.
Thank you very much for that, David. We've got about 5 minutes left, so I'm going to pick a couple of quick questions that I hope we can deal with relatively swiftly. First one is a question for Ralph. Ralph's talking about the 1954 Act, and the question is, do you think the government would ever be bold enough to simply abolish Part 2 of the Landlord and Tenants Act 1954?
Right, thanks, Bill. Interesting picture there of me and my pre-lockdown haircut, as opposed to the rather hairier me that's arrived some 12 months later. Yeah, Rachel mentioned in her talk that there has been a suggestion later this year that the government might do something in relation to the 1954 Act. I mean, whether or not they choose to abolish it altogether, I don't know. What I would say is that periodically there has been talk about them doing away with the Act. We had the changes that took place in 2004, which I think addressed to a certain extent some of the concerns that people had with the Act. Those changes have bedded down. I think on the whole they work reasonably well. I think there is still a question mark as to the extent to which the courts need to be involved in the whole process. So there may be some tinkering around the edges to come. Rather than having the courts involved, there have been pilots down in London. So the property, the upper tribunal that deals with property cases deal with lease renewals as opposed to the courts. It may be that they'll mandate that, so that happens in relation to all lease renewals as opposed to just where they've been running the pilots. I'm not sure to what extent that's a good idea or not. My experience in relation to the upper tribunal is that becomes more expensive because you have tighter directions, timetables, and more things need to be done more quickly. In Scotland, they don't have the 1954 Act at all. There's no security tenure. And speaking to colleagues who deal with work up there, they seem to think that works reasonably well. I'm not sure you could just sort of have a short, sharp shock here and say we're going to abolish the 1954 Act and there will be no security of tenure as from to tomorrow. I think there need to be some sort of transitional arrangement if that was going to happen. And I'm not sure the government would necessarily be bold enough to do that. The other two comments I would have, I think excluding leases from the Act is becoming increasingly prevalent. Where TFS stores are trading was mostly in shopping centres, and I think I'm right in saying that a lot of shopping centres now, all their leases are excluded as a matter of course. I think following the pandemic, I think there are going to be huge changes in the property industry. We're all sat here at home delivering these talks, whereas this time, well, not this time last year, but 18 months ago, we'd have been sat in an office. All those office spaces are sat in Liverpool, London, Manchester, or whatever. They're largely empty. And I think that's going to give rise to a fundamental shift in relation to the property market, not just offices, but shops as well. If you are able to get out onto a high street, You can see the impact that the pandemic has had in relation to the number of closed shops. So I think there is going to be a big shift in relation to the property market once things get back to normal. That may give rise to different views in terms of the landlord and tenant relationship, and I suppose it's possible that the government may feed into that in terms of some changes around the 1954 Act. We'll have to wait and see. Obviously, if they do get rid of the Act, that's going to be me out of a job, because I've spent a large part of the last 25 years advising on it. So I shouldn't perhaps turkeys wishing for Christmas to a certain extent, but we'll see. Thanks, Bill. I hope that goes some way towards answering or not answering the question.
No, thank you very much, Ralph. That's fascinating. So we'll have to wait and see what happens. Right, we're bang on 11:30. So I'm going to bring matters to a conclusion now. I'd like to say a very big thank you to all our speakers this morning, and to all of our delegates, for all of you guys for joining us. Please do watch out for that follow-up email in the next couple of days, and we look forward to seeing you all again at our next events. So have a great day, everyone. Thank you and goodbye.